A patent protects inventions that satisfy certain requirements. There are 5 basic requirements in order for you to get a patent or an invention. So only if your invention satisfies these 5 requirements, you will get a patent. The first requirement is patentable subject matter. The second one is usefulness. Third one is novelty. Fourth one is inventive step. And the fifth one is enablement. Enablement is in fact part of our requirement called as specification. Now the first requirement, patentable subject matter. This is a requirement which I normally refer to as the government's requirement. Using this requirement, the government decides what is the subject on which it wants to grant a patent and what is the subject on which it doesn't want to grant a patent. So it has 2 prongs here. It has an eligibility prong and an ineligibility prong. Using those prongs, it tells you what can be patented and what cannot be patented. So if you look at it in India today, and by the way, each country has different, uses these prongs differently and has different scopes for each of these prongs. In India, products and processes are considered to be patentable. However, there is a long list of inventions which the government says are not considered to be patentable inventions. In other words, there are a long list of inventions, which are about 50 of them, which are not patentable in India, irrespective of the fact that they are useful, novel, inventive, and they're actually inventions, good inventions. The government just decided that it will not grant patents on those subjects. Now, if you look at the US, the list is very small. They have only 4 or 5. Europe has around 15 to 20. India has close to 50, which are not considered to be patentable inventions. For example, in India, animals are not patentable. So if you come up with a genetically modified cow that gives 200 liters of milk in a day, you cannot get a patent on it because animals are just not patentable. Same is the case with plants. Business methods are not patentable. So if you come up with a method of increasing the profitability of your company by managing finances efficiently, you cannot get a patent because business methods are not patentable in India. Presentation of information is not patentable. If you come up with a wonderful PPT that will allow you to pitch to your customers in an efficient manner so that you are able to close a deal, you can't get a patent on that. Computer programs per se are not patentable. So when you look at computer programs, the law looks at them, or law classifies them into 2 types. Computer programs per se and computer programs not per se. Computer programs per se are not patentable. Computer programs that are not per se are patentable. Now, what is the difference between the 2? A computer program that is standing alone on a general purpose computer is a computer program per se. And a computer program that is not standing alone or that is not meant for a general purpose computer is a computer program not per se. For example, a music player on your desktop is a computer program per se, and it's not considered to be patentable. On the other hand, a music playing software or application for a special device such as a mobile phone is considered to be a computer program not per se, and that would be patentable. Now, in today's context, even mobile phones are similar to computers. They are also considered as computing devices, but the law has not reached there yet. It considers mobile phones as special devices and therefore considers any application or program on a mobile phone to be not a computer program per se, and therefore is patentable. Same is the case with computer programs that interact with hardware, computer programs that are embedded in hardware, and computer programs that collect data from multiple locations, interact with different servers, and so on and so forth. So computer programs per se are also not patentable. So like this, there is a list of several subjects that are not patentable in India, irrespective of however innovative they may be. Then the next requirement is usefulness. In order to get a patent, an invention must be useful to at least one person. It need not be useful to the society at large. Even if one person finds it useful, that's good enough. The next requirement is novelty. An invention must be different from what is already existing in order to get a patent. When will an invention be different from what is already existing? If it has at least one difference from what is referred to as prior art. What is already existing is normally referred to as prior art under the patent law. And this prior art includes prior products, prior publications, prior knowledge, prior patents, and so on and so forth. So to determine whether an invention is novel or not, you need to pick each prior art reference that is related to the invention and compare it one by one with the invention, or compare each of the prior art references individually with the invention. And during this comparison, if you find that there is at least one difference, then the invention will be considered to be novel. For example, let's say there is a pre-existing product, and you have come up with an invention that is related to that product. Let's say there is a jug. You came up with a jug. You know, what is the role of a jug can be multifold, one of which is holding water. You came with a jug that you feel is innovative. Now, you want to check if it is novel or not. Your jug should have at least one difference to what is already existing. There is at least one difference, then it is considered to be novel. Let's say there is a publication which talks about how jugs can be made. When compared with that publication, your jug must have at least one difference. Then it's considered to be novel. But the next requirement, which is referred to as inventive step, requires the prior art to be combined. In novelty, you cannot combine two. In fact, as I mentioned earlier, you cannot combine a pre-existing product and a pre-existing publication and see if there are any differences. You have to see each of them individually in novelty. But when it comes to inventive step, you can combine these two. And once you combine these two, you have to see if there are any differences between the combination and the invention. And who should feel these differences? It's not you as an inventor, but it's a person who is skilled in the field who should feel those differences. Right? So if a person skilled in that particular field of jug making feels that based on the prior publication and pre-existing jugs, your invention is not obvious. In other words, your invention is not simple or is not the result of basic mechanical workshop improvement, then your invention will be considered to be inventive or satisfying the inventive step. So that's the next requirement, inventiveness or inventive step. And the final requirement is enablement. In order to get a patent, you need to describe your invention and submit a specification. And if I want to make your invention, by reading your description, I should be able to make it. That is what is referred to as enablement or workability. So 5 requirements: patentable subject matter, usefulness, novelty, inventive step, and enablement. If you satisfy all these requirements, then your invention will be eligible for a patent grant. If you get a patent, you get this patent for 20 years. After 20 years, it enters the public domain. You get 5 basic rights when you get a patent. I told you earlier that intellectual property grants exclusive rights. If you get a patent, you get 5 exclusive rights. You get the right to make, right to use, right to sell, right to offer for sale, and right to import. And one important point you need to remember about patents is, if you get a patent in one country, it is valid only in that country. If I get a patent in India, it's valid only in India. I cannot stop somebody from making my invention or selling my invention in the US. If I want to stop him, I'll have to get my patent in US as well. However, while granting a patent, the patent office will look at what is pre-existing across the world. And if your invention is not existing anywhere in the world only, it will grant you the patent.